still unfolding, so I will not pretend to carry you past where the record goes. We follow the argument exactly as far as the page allows, and not one sentence further. But even with the page cut short, the shape of the collision is clear, because it has been clear from the very first sentence of this case. Two convictions, each held with a kind of certainty that leaves no room for the other. On one side, the conviction the court had already given voice to through the doctors of the last century, that this is human life, that a matter of this gravity admits no compromise, and that an honest mind is bound to call it by its proper name. On the other, the woman the record calls only Jane Roe, a single claim, quiet beside the weight of the statute books, that the decision was hers, that it belonged to her life, her body, her future, and not to the state of Texas. And so the question the court carried, the question it had reared and held and turned over for more than a year, came down to this. Could a right the Constitution never names be strong enough to take that decision out of the hands of the state and place it in the hands of the woman herself? In 1973, 9 justices answered, and the answer they gave would not stay settled. The opinion you and I have been following breaks off before its conclusion, but history records where it landed. When the writing was done, the court affirmed that Jane Roe had the right to bring her case at all, and it agreed with the heart of the lower court's ruling, that the Texas criminal abortion statutes could not stand under the Constitution. The decision was not a clean sweep. The court reversed the relief that had been granted to Dr. Holford, the physician, sending him back to face his pending prosecutions in the Texas courts. And it let stand the dismissal of John and Mary Doe, the married couple whose claim it found too speculative to decide. Affirmed in part, reversed in part. The law is rarely as tidy as the headlines that follow it. That contested answer would govern American law for nearly half a century. And then, in June of 2022, in a case called Dobbs against Jackson Women's Health Organization, the Supreme Court reversed itself, and Roe was no longer the law of the land. So hear this clearly. What we have walked through tonight is history, not the rule that governs today. Which leaves a harder question for another night. The case that undid this one, and what it means when the same court that can find a right can later decide to take it away. Justice Blackmun had set out to resolve the most divisive question in the country by constitutional measurement alone, free, as he put it, of emotion and of predilection. Whether any court could ever truly manage that with a question like this one is something the nation is still arguing about. And perhaps on the 22nd of January, 1973, the Supreme Court of the United States decided a case called Roe versus Wade. 9 justices had been handed the most divisive moral question in American life, and asked to answer it not with feeling, but with law. But before the court resolved anything, the justice writing for the majority did something you rarely see in a Supreme Court opinion. He stopped to admit how hard the question was. Justice Harry Blackmun opened not with the law, but with a kind of confession. He wrote, and these are his words, "We forthwith acknowledge our awareness of the sensitive and emotional nature of the abortion controversy, of the vigorous opposing views, even among physicians, and of the deep and seemingly absolute convictions that the subject inspires." Deep and seemingly absolute convictions on both sides. And still, the court would have to choose. That was its burden, to settle a question the nation itself could not agree on, using a constitution that never once names the right at the center of it.